Even with careful preparation and professionalism, not every real estate transaction in Arizona reaches the finish line smoothly. Sometimes a deal falls apart due to buyer default, financing failure, inspection disputes, or unforeseen life events. When this happens, escrow officers, agents, and brokers must handle cancellations, earnest money disputes, and possible legal actions correctly and in compliance with Arizona law and commissioner's rules. Understanding escrow's neutral role. Escrow officers are neutral third parties. They cannot take sides between buyer and seller. Their role is to follow the written instructions of both parties exactly as authorized in the purchase contract. When those instructions conflict, or when one party cancels improperly, escrow must stop and hold all funds until both parties give matching instructions or a legal order is received. Under ARS, paragraph 6.834, escrow agents are legally prohibited from releasing funds unless the written escrow instructions are fulfilled. This statute protects all parties from unauthorized disbursements. Example: a buyer in Scottsdale backed out after the inspection period expired, believing they could still cancel. The seller refused to release the earnest money because the contract did not authorize release without mutual agreement. The escrow officer held the funds in trust pending resolution. This neutrality preserves the integrity of the escrow process and prevents either side from being unfairly disadvantaged. Contract cancellations under Arizona law. Arizona Association of Realtors, AAR, purchase contracts clearly outline when and how a buyer or seller may cancel a transaction. Common legitimate cancellation scenarios include inspection period cancellation, Section 6J of the AAR contract. Financing denial with proper documentation, Section 2B. Appraisal shortfall, if not waived, Section 2K. Failure to deliver disclosure documents within statutory timelines, ARS, paragraph 33.422. If a party cancels outside these conditions, they risk breaching the contract and forfeiting earnest money. Example: in a Mesa transaction, the buyer canceled 2 days before closing because they found another home. The seller claimed the buyer was in default. Escrow followed the AAR contract procedure and held the funds until mutual written release or court direction, protecting itself and complying with ARS paragraph 6.834. Earnest money disputes. Earnest money represents a buyer's good faith to perform under the contract. When disputes arise, the funds cannot be released to either side unless both parties agree or a court orders release. If no agreement is reached, the escrow company may file an interpleader action under Rule 22, Arizona Rules of Civil Procedure. An interpleader allows escrow to deposit the disputed funds with the court, withdraw from liability, and let the judge decide which party is entitled to the money. Example: a buyer in Chandler demanded return of their $10,000 earnest deposit after inspection, claiming the seller failed to disclose roof damage. The seller argued the buyer waived the inspection period. When no mutual release was reached, the escrow company filed an interpleader. The court later awarded $7,500 to the buyer, $20,500 to the seller, and released escrow from the case entirely. Broker and agent responsibilities. While escrow remains neutral, agents and brokers have professional obligations under R4 to 28-1101A and R4 to 28-802A to protect clients and act promptly when disputes occur. Key duties include advising clients of their contractual rights and obligations, delivering all cancellation notices or amendments to escrow promptly, avoiding unauthorized legal interpretation. Only attorneys or mediators may determine entitlement to funds. Documenting every communication related to cancellation or dispute. Example: an agent in Phoenix immediately notified escrow when their buyer's financing fell through and submitted the cancellation form before the loan contingency expired. This protected the buyer's earnest money and demonstrated compliance with both contract terms and commissioner's rules. Mediation and legal resolution. Most AAR contracts include a mediation clause requiring parties to attempt resolution before filing a lawsuit. Mediation is a neutral process where a trained mediator helps both sides reach a compromise. If mediation fails, parties may proceed to binding arbitration or civil court, depending on the agreement. Escrow will maintain the funds until receiving either mutual written release or certified court order directing disbursement. Handling escrow cancellations professionally. When a transaction cancels, escrow officers must 1. Confirm written cancellation instructions from both parties. 2. Verify that any earned fees, such as title search or courier costs, are deducted before refund. 3. Retain all records for a minimum of 5 years under ARS, paragraph 32-2151-01A. 4. Return funds only through traceable methods, check or wire. Agents should always communicate clearly and avoid making promises about refund outcomes until escrow confirms all legal requirements have been met. Example: in a Glendale sale, both parties agreed to cancel after inspection revealed foundation issues. The buyer and seller signed mutual cancellation instructions. Escrow deducted title and courier fees and returned the balance to the buyer within 48 hours, an example of ethical, compliant closing of escrow. Arizona example. A Tucson transaction collapsed after an appraisal came in $25,000 below the purchase price. The seller refused to lower the price and the buyer canceled under the appraisal contingency clause, AAR Section 2K. The agent submitted the cancellation in writing before the financing period expired. Escrow refunded the buyer's earnest deposit, fully compliant with contract and statute. If the buyer had failed to act within the contingency deadline, the seller might have claimed the deposit, resulting in a dispute or interpleader. Key takeaways. Escrow officers must remain neutral and cannot release funds unless authorized by both parties or ordered by a court. Agents must promptly deliver cancellation notices, follow contract timelines, and document all communications. Understanding ARS, paragraph 62834, R4 28802A, and the AAR residential purchase contract helps ensure proper handling of disputes, cancellations, and earnest money under Arizona law.